Welcome, everyone. I'm Ray Snytsheuvel with Garris Horn. This is another episode of Garris Horn Insights. Today, I'm here with my law partner, Troy Garris. In this episode, we're actually going to address questions regarding loan compensation rule, and the questions cropped up in a webinar that Troy and I did a few weeks ago. So in fact, if you haven't seen that webinar, it is in our YouTube channel. You can take a look at it, like it, subscribe, everything else. But anyway, the context of our responses or of our conversation here, responses to questions that came up in that webinar. So we thought this would be a good place for it and let everybody know that's how we responded, because we thought this would be a good discussion. So Troy, thanks for joining us, of course, taking your time out to do this. And I thought we jump into it. Any initial comments before we jump into the questions?
No, thanks, Ray, for doing this. Yeah, this is a really cool way to respond to the question. We did get a bunch of questions, and I will point out that none of these are somewhat more specific than we talked about on the webinar. So none of this is legal advice for any particular person. It's just general information. But I do think it'd be helpful because I hear this a lot in the hallways and elsewhere.
Yeah, agreed.
These types of questions.
Very good. Well, thanks, Troy. So let's go through it. We'll start with the first question, and we'll take it from there.
Sure.
And see what they ask. So I'll read the question, ponder your thoughts on it, and I'll kind of chime in as well, and take it from there. So first question that we got from the webinar: can an outside sales exempt employee be part-time? Troy, what are your thoughts about where's that question going? Where's your answer going on that one?
Yeah. So. This is really a wage and hour question rather than LO compensation. So it's related, but it's a little different from our main focus today. But the wage and hour, and let me just talk federal. There's state laws in a number of states too that you got to worry about, in particular California, but there are others that are complicated too. But at the federal level anyways, the general rule is that every person who's working in the United States has to be paid at least a minimum wage, and if they work more than 40 hours in a week, they have to be paid overtime at their regular rate, they call it, which is a calculation that includes almost everything. So it includes, hourly wages, it includes salaries, it includes bonuses, it includes commission, it includes almost everything. There's a few low carbons, but that's the basic rule. Pay everybody minimum wage and overtime, unless they're exempt. And one of the exemptions is this outside sales exemption. And the outside sales exemption basically says those rules don't apply, those standard rules don't apply if two things happen. One is your primary duty is sales, and two, you're customarily and regularly outside any fixed location engaged in that primary duty. And so that's really the pivot point. It's not so much whether a person is part-time or full-time. It's really whether the person is outside engaged in primary duty sales customarily and regularly, or they're not, in which case, unless another exemption applied, they have to be paid under that minimum wage overtime rule. Now, overtime is after 40 on, at least the federal law. So, over 40, if you're working part-time, probably you're never going to run into that overtime issue. But nevertheless, that's probably where it comes down.
And I can tell you again, not legal advice, but as I'm a California attorney and dealt with this, California is 8 hours, right? So
yeah, in a day, that's right. And there's some other complications too,
right, exactly.
Yeah.
So oddly enough, you can have a part-time person who's getting overtime in California, right? So if you think about it that way, I think that I saw this question too, and I think first of all, you're right. I think it's not a loan comp issue per se, but it kind of, when you talk about compensation with loan officers and how you engage them, how they're employed, a lot of things come into play, not just the loan comp rule. And we can talk about that later. But I think the best way to look at it is, having someone who's an exempt employee, however you define that, whether it's general exempt or the outside sales exemption, whichever, there's no prohibition that they could be part-time. So in theory, it could happen. But again, it's all the elements coming together and finding out with the part-time, they're this to that. you put it all together, you put it in a little magic 8-ball, you shake it, and it says, is this legitimate? And it might not be for various reasons when you start adding these ingredients. So in and of itself, it doesn't look like it's prohibited, but you got to put everything in the totality of the wage and hour to find out, is this particular arrangement okay, given everything that we know? And the answer is, I guess it's not per se illegal or wrong, but it's a very complex issue. I would always say check with with wage hour counsel or anyone or in-house or HR department to find out, because these are really intricate rules. But that's what I think.
Yeah. There's also other things to play in, like the licensing rules and that sort of thing. So that it's complicated, but it's a general matter. That's right.
Let me get another question, and I think it's similar. It probably relates, and maybe we similar response or same response. So let's find. Should an outside sales exempt employee record their time worked? If so, what are the best practices? So again, timekeeping, I suppose, is the question for. We're saying outside sales exempt. What are your thoughts on that, Troy? Again, wage hour, right?
Yeah, it's a wage hour issue. It's that same rule that I just talked about, right? So, and these are outside sales. And so these are people that we've decided, okay, so these are exempt outside sales employees. So the minimum wage and overtime rules don't apply. Now, the question about should you make them track their time, I think as a general matter, there are people that come out in different ways on this, but as a general matter, I would say yes, because and the degree to how they track their time could be a little less daunting than in the normal person, covered or non-exempt person, because the rule for keeping time doesn't really apply. But if you claim that the person is outside sales exempt and the person then files a claim later on, as the employer, you have the burden of proof to prove that they qualify for this outside sales exemption. And if you've tracked their hours and they say, on Monday, I'm out at the golf course, and, in the morning and in the afternoon, I was at this open house that I stopped by at, and I started talking to some consumers. And on Tuesday, I was in several different open houses talking to consumers. And on Wednesday, you're moving around, you're out drumming up sales. You have a pretty good track record of what you're doing. And then when somebody comes in and says, yeah, I wasn't really outside, you have this documentation that says, well, exactly. It says here you were. And so something is amiss. And if you didn't track anything, you can still get perhaps cell tower records and computer records and the like, but it's complicated, right?
It is.
And so it seems like having documentation serves you better. Again, there's some people that would disagree and think that it's better to not have that, and we can talk about that if we want to,
but you're right. I think just generally, and particularly in these two questions, and having dealt with this a lot when it comes to wage hour, is when it comes to exempt employees, and now we're really talking about outside exempt employees, 100% commission, whatever it might be. All of those are within bounds of laws, but there's a lot of requirements. And my experience has been it's trickier than just labeling something or labeling somebody some certain way. There are very specific things you can and cannot do in those situations. So, for example, if you're outside sales, going to your point, Troy, they're in the golf course and they're networking, and then they went to open house. They're supposed to do that. Flip side is they're not supposed to be inside. They're not at their home office or the office that the corporate office, because they're supposed to be outside. If you're outside, it's 100% outside. So if you have evidence that they actually have an office indoors, that might not help your cause if you think they're, quote, outside. Again, not saying that it's wrong to have that completely. It's just this doesn't help when you're trying to show that someone is outside sales. So very good.
I will just touch on the percent. So in the federal law, you have a rebuttable presumption in your favor. If the person is more than 50% outside engaged in this type of activity, then the person would qualify. And if the person is less than 50%, you don't get that rebuttable presumption in your favor. Now, some states, California is one of them, is a much more objective test, which objective tests are great in some ways because you know where the bright line is. But if you fall below the bright line, then it causes you problems.
Yeah, like anything, prescriptive laws are great until they're not prescribed the way you want them to be. So understood. All right, next question. Question number 3. Again, this is from our loan compensation webinar we had a few weeks ago. And these were questions from people who were on the webinar, and we thought we'd respond here. So question number 3, loan officer paid 1099 and doing government loans, ? By the way, I'm doing verbatim, so if it isn't a full sentence is how they came up. So The question is, loan officer paid 1099 and doing government loans? Question. I think the implication is, can you be 1099 and do government loans?
So, I think we're getting distracted a little bit on the government loan piece, because I think the first question really is, can you, as a 1099 contractor working for a creditor or working for a mortgage broker, can you be a 1099 contractor? And I said this in the webinar, but I'll repeat it here. We get hung up on these terms, 1099 versus W-2. That doesn't really mean anything. What really means something is, are you an employee, in which case you get a W-2 that reports your income, or are you a contractor, which means that your compensation gets reported on 1099. So that's really the distinction. It's not that form, the name of the form. It's really what you're doing.
Right.
And so as a person who is acting as a loan originator for some creditor or as a loan originator for some broker, if I'm a 1099 contractor, then it seems to me like I have potentially a lot of problems unrelated to whether I'm doing one kind of loan or a different kind of loan. Because if I'm a contractor and I'm handing out business cards with my employer on the business card, so it says ABC Mortgage, so I'm handing that out and saying, hey, this is my employer. This company sponsors me on the NMLS. This company is listed as the person who has my phone number. This person, this employer, this person, I use their LOS system. I use their underwriting. I use, like, everything I do is through this particular company. Seems to me it's pretty hard to say I'm a contractor instead of an employee. So I have probably, if people are treating me as a contractor, they're not withholding payroll taxes. They're not withholding for unemployment insurance. Probably they're probably not paying in accordance with minimum wage, overtime, or exemption rules. Like, there's this whole panoply of likely problems that come up with somebody treating somebody as a contractor. In addition, if they're right and I actually am a contractor, then when the lender pays me, how is the lender being able to pay a contractor under RESPA Section 8? Because payment to an employee is exempted under RESPA Section 8, but payment to a contractor for a referral, which is what the person would be doing, referring a loan over to the lender, how would that be exempt under Section 8? Now, it could be that person is acting as a broker, so that would turn the lender into a wholesale lender, essentially. So that contractor is sending me a loan, and it makes that person a broker, and I can pay that person as a broker. But then, did I disclose right on the TRID forms? It's this nightmare
and you get
of issues.
right, and you get the whole host of things. You have to do a number of these services to be rendered a broker, right? So
right.
It's what I've witnessed and what I've experienced also with this question. First of all, I think this is my expectation is this question was triggered by FHA and say something about that you can do, I want to say, dual employment or something to that effect, and then maybe has now kind of extrapolated into, can you be 1099? And that's how I've seen it talking to my clients, and I have done the survey of 1099s. In other words, the first question is, can you be a 1099 under the licensing law, right? So under the SAFE Act in each state, can you be a contractor or basically a contractor paid by 1099? And most of the states said yes. Some of them said no, but more than I thought actually said no. And it's really within the structure of the law in most cases. But I do have that survey. I do know what states you can and cannot. But that doesn't solve that. Go ahead.
Yeah, because the question that they're asking there, or that the state is addressing, really is, does the state licensing law require you to be an employee
correct
versus a contractor in order to be sponsored in that state? And the answer in some states is no. We don't get into whether you're an employee or a contractor. We don't care. You got to be sponsored by a licensee, and you got to be attached to the licensee in NMLS. But it's a different question, right?
Correct. Correct. And in fact, in many states, because I did this via correspondence, they would remind you there's a whole host of other thresholds that you got to meet to be a contractor, and wage and hour. They kept referring back, which we are discussing here. And in that context, I'm aware of that. I had a strict question of whether the licensing law required it or not to be an employee. Right. And that was the scope. But we all know there's other issues, and that's what we're trying to figure. So whether it is with FHA loans, whether you can or cannot, and this is where they're coming out, you have a real estate agent one way, and they can be the broker, or they can be a loan officer also in the same transaction under the umbrella of a lender over here. Can that be done? The answer is, well, in some sense, yes, but how do you solve for so many things? And I think, for example, the RESPA issue, it's if you're the real estate agent in one company and the loan officer in another, the legal question is, well, it's my same client, it's not a referral. It's like, well, is the referral defined by the person or by the company? And so it's a referral from one company, exactly, from one company to the other, even though it's the same person. So now we haven't solved for the RESPA issue. There still might be a referral. We don't know. This interpretation by CFPB at some point that might come up. My point is these complexities come up about RESPA, wage hour, licensing, amongst other things. I think we talked about, obviously disclosure laws, who's doing what, conflict laws had come up. But it was in that context. So I think the answer is loan officer paid 1099 doing government loans? It's like, wow, that's a big question. We're going to need to have more details to find out, in your case, how we navigate this so that it fits your needs, or at least to a point that these are the facts you have when you come out with, yeah, it's not going to work. We don't know. I mean, So we're not saying no to everything. We're saying is be careful. There's a lot of tripwires, and it takes thoughtful and very focused conversation, fact specific, to come up with the right answer. Does that make sense, Troy?
It does. And if somebody out there is already treating people as contractors paying on a 1099 basis, I'm not saying there are no defenses. There are. Correct. And in fact, in some states, licensing laws, for example, it's clearly allowed. It's just that, to me, it seems like it raises a lot of questions that most people would probably rather not have to answer. And I don't know if like our mutual friend frequently says, I don't know if the juice is worth the squeeze.
Right. Yeah, I will tell you that you bring up a good point. And in our responses here, we're really trying to establish good policy positions. And, Troy and I are familiar with law. We have good litigation within our law firm. Our answers are not focused on, because when we go to court, here's how we win. That's not the point. Our point is to give you good direction so you don't have to see court. But if you do, we have defenses. So we don't want to scare everybody into saying this is the only answer, but we're talking policy level, right, Troy? So, so I think so you get those people doing other things, not scaring them off, saying it's wrong, because there are defenses as well. We're just saying, generally speaking, here are the things to think about. Let me get to the next question. So here's the question. I'll get rid of the acronym. So borrower paid compensation versus lender paid compensation. Borrower paid compensation versus lender paid compensation is more of a discussion than broker versus banker. The fact is, banker is all borrower paid compensation from the MLO perspective. Agree? Question mark. I'll be honest with you, I'm not sure the scope of the question. My response to that would be, I need more clarity for conversation. I don't want to speculate too much. But to that point, because Troy is good at this, he can read tea leaves. He knows what the river card is going to be. So where do you think this question is going, and what are your thoughts?
Yes, it does leave a lot unsaid. But I think what they're talking about is they're making the distinction between a broker scenario where you can have, in a broker transaction, you can have borrower paid compensation, in other words, borrower paying the LO directly, or you can have, most people call it lender paid compensation, usually the wholesale lender paying the loan originator. And in a broker transaction, that's true. In a creditor transaction, it wouldn't be true. If the entity ABC Mortgage is a creditor, in other words, what we would normally refer to as a lender, right? So creditor under TILA language. So if that lender is the creditor, then the borrower is always going to be paying the creditor for, origination fees, for whatever transaction costs there will be. The borrowers will be paying that creditor, but the creditor is not a loan originator in the creditor scenario. Now, occasionally they may flip over and turn into a broker momentarily, because most of the time they're a creditor and they're doing their own loans, they're underwriting, they're closing their own name with their own funds, et cetera. They're a creditor, right? But every once in a while, they may say, you know what, we don't have a product, or we don't have a particular something that serves this particular borrower. So for this moment, we're going to turn into a broker, in which case you could have a borrower paid compensation versus, again, the wholesale lender paying what used to be a creditor, but for the moment is now a broker. But I think that's what this question is trying to get to. So, and it does ask, it seems, is all payments by the borrower to the creditor a borrower paid transaction? And the answer really in the LO comp sense is no. It's a payment by a borrower to the creditor, not a payment by a borrower to a loan originator. So it's just not covered by that LO compensation rule. I don't know if I made that better, but
yeah,
that's what I think we're trying to do.
And I don't recall if the questions hit this, but we may able to touch it real quick here. I think we talked about it in the webinar, but I think the impetus for this as well. Well, your response, I think, spot on to where it was going, but I think the impetus otherwise was the highlights issued by CFPB regarding an examination, not enforcement, where they saw that somebody was paying, that a lender was paying differently for broker transactions than in-house transactions. And the key there was, and actually I think it'll come up again in another question, and that is they were brokering the reverse mortgages, and the forward mortgage they were doing in-house, and the CFPB says you cannot do that. I don't think what we have clarity on is what is that. Was it that we know that you can't pay by product, okay, but by in terms of the transaction and whether reverse mortgage versus not, that could be terms of transaction. I get that, but we're trying to see, we're reading into, does that mean you can't, if you're doing the same kind of loan and one is you're brokering one sometimes and keeping in-house another time, can you be paid the same, or can you be paid differently for those that are brokered to your loan officer? The answer might be yes, assuming it's the exact same loan and same terms and there's no difference there. We don't know because it wasn't made clear. I'm going to simplify really what they said in the highlights, because but really it was like, yeah, we saw that happen. You can't do that. It's like, okay, well, what did you mean by that? Is it because it was because they were two different types of loans, or was it because one was broker and one was in-house? And I think we can afford clarity in the future, but I think I kind of know where I land. Troy, what do you think on that? I kind of made up a question, but I think it's going to permeate some of our future questions, so it was important.
Yeah, so I do agree with that. It's unclear, the language in the summary and the highlights summary. It's not entirely clear what they're talking about. What they seem to be saying, cutting through a lot and assuming a lot, is that you cannot pay a creditor now, right? So we're not talking borrower paid versus lender paid. We're not talking about that. We're talking about, can a creditor pay its loan officer, loan originator, differently based on whether a loan is brokered out versus a loan is done in-house, where you do the underwriting, close, and fund in your own name. That's what they seem to be focused on. And they mentioned these two different types of products and said, well, they said we encountered a situation where people were a lender, a creditor was paying differently on this basis for reverse mortgages versus presumably like cash out refi or something along those lines. And so you had these two different types of products, and you're paying differently based on product rather than paying differently based on that this particular loan is brokered versus this other particular loan is done as an in-house loan. That's what they seem to be talking about, but it's still a little unclear. And I think most of the industry has historically interpreted, in fact, the MBA itself has historically interpreted this as being, somewhat unclear but allowable. So I think, from my conversations in the hallways and elsewhere, that a lot of people have historically interpreted the rule this way, and so this seems to be a change, potentially a sea change, whatever that means exactly, but a pretty important change that people should be at least thinking about and managing through what they think is the appropriate interpretation and level of risk in their scenario.
So Troy, next question that we got
Yeah.
from our listeners at the webinar, participants, regarding the dual compensation prohibition on consumer paid. What do you think about the argument based on the definition of, quote, term of the transaction, close quote, in the rule? The loan transaction and the purchase and sale transaction are separate transactions, so there is no dual compensation when a party is paid as the loan officer for the loan transaction and also paid a commission for the real estate agent on the purchase and the sale transaction. And basically,
Yeah.
as you know, Troy, this is basically where you got a person who is both the sales agent and the mortgage loan officer, and the payment of which will come from two different sources. But the loan comp rule says you can only get paid by one source. So when we say transaction, when CV says transaction, we're talking about the whole thing or the loan transaction. That's the scope of the question. What do you think?
Yeah. It's a great question. It gets fuzzy too, and in fact, it's quite possible that the LO who is acting in this dual capacity actually may be acting in three capacities, because they may be they have a consumer who wants to sell their current house, so they're going to get paid by the consumer to sell that existing home, and then they're also going to get the consumer a new home, and they're going to get paid a split of whatever that selling agent is getting paid by that other, by the seller over there. And then in addition, because they're going to operate as a loan originator, they're going to get paid by the company, the lender, as a loan originator on the transaction.
It's a lot to digest. It's exactly
it is, right? And the thing is, I don't think there's any regulatory guidance that's really out on this yet. I can see that, like the person asked here, I can see how each of these are completely separate transactions, and the LO comp rule does in fact talk about particular transactions. I think the LO comp rule really is focused on the finance transaction, so the loan itself, and that's why the conversation and the language in Truth in Lending is talking about loan originators, and they're talking about creditors. That seems to talk about only the finance transaction, not the real estate transaction, the sale of the dirt and the fixtures attached to it. That real estate transaction seems to me that it's a separate term. It's a separate contract. The whole thing is separate from the finance transaction that the LO is getting paid on. But could you imagine a regulator questioning that or second guessing that? Maybe. And so I think people need to think about that, take into account, and talk to the risk management folks or compliance folks.
Agree.
And figure out an approach that they think makes sense, and then document clearly why they made that decision and how they put up barriers and have those distinctions.
Agree. And I think it's a great question, the way it's posed.
Yeah,
I think the analysis of where they want to go with it, I think is a good one. If you're asking me, can I guarantee there's not going to be a problem? No, but the logic seems pretty sound, and that's at least hopeful. So appreciate that, Troy. Let me jump to the next question. If a company pays the loan officer the same basis points for all loan types across the board, can the company pay discretionary bonus to the loan officer on a quarterly basis? So now we're talking about paying a loan officer bonuses, and in this, they use the term here, discretionary bonus. And I think both you and I cringe a little bit on that one, because we don't know what that means, and that can be flipped against the interest of lenders by those who scrutinize us. But anyway, go ahead. What are your thoughts? I have some thoughts, but go ahead.
Yeah. So, and you probably come out the same way on this, is my guess. But so the idea of paying a loan originator the same, I'll just call it basis points, the same basis points across the board, all loans, every loan the loan originator does in the particular period is the payment's the same. And then on top of that, on a quarterly basis, they're going to come along and pay on a discretionary basis this other bonus. And the real answer, I think, is not so much whether it's discretionary or not. It's really whether it's done for an okay purpose. Is it based on profits? Is it based on terms of loans or proxies for terms of loans? If it is, it's definitely going to be impermissible. Is it based on the flip side? Is it just based on volume, which is allowable? So if for example, if I set up a program and said, if you do 50 loans in this quarter, then I'll have the discretion to give you a bonus. Well, probably, again, assuming there's nothing nefarious behind the scenes going on for calculations, probably that's going to be okay. I do think that the discretion injects a bit of risk there, but it really got to look through to the actual purpose. Is it terms of loans or not?
Yeah, and I think you'll be indicted, and on the terms of discretion against your interests, and you have to explain yourself out of that. I think that's the challenge. So you'd rather not be in a situation, discretion, and show that it wasn't because of profitability, et cetera, which, by the way, often discretion bonuses, just generally speaking, are because of that. So you have to talk your way out of it. It's better to structure it where it's black and white. I think there might be some room maybe in that 10%, possibly in the 10%, what is it, non-deferred that you can pay.
Profit-based bonus.
Profit, yeah. But even then, my caution always there is the 10% isn't what you think it is, meaning calculating what people have earned and what's 10% of that and putting in, there's a lot of mathing involved in doing that. So I don't want to say, well, assume, well, they made $50,000, so I can do $4,999 and give them that bonus and they'll still be okay. It's not quite that simple. So, it's one of those, if that's the case in any case here, and certainly in even the 10% case, talk specifics with the people you talk to in compliance and legal to make sure you get it right. But the short answer is I cringe a little bit when we're talking about a broad question of can we do discretionary bonuses? The answer is I'd start with, why do you ask? And it depends. I don't want to say no. I want to have the conversation, but I can't say yes until I know more details. So that's kind of where I fall on that one. So we're on the same page.
Yeah, for sure.
The question number 10 is concessions. The next question I should say is concessions. Something got out of the order. I apologize. Concessions. Can a company deduct concessions on an originator branch manager's profit and loss? I'm gonna tee this up a little bit, Troy. I'm expecting here we're talking about not an originator only, not a branch manager only, but a branch manager who's also producing, therefore is also a loan originator. So they're doing both sides of it and gets a little complicated. So in essence, what do we do in a situation where we have a branch manager? His branch manager he's paid on a P&L, but by the way, he's also a loan officer in his own branch. Thoughts on that?
Yeah, so I think that really is the pivot point here. So on the one hand, you have non-loan originators. They aren't actually covered, right? So non-loan originators, you can the creditor, the employer, can pay that non-loan originator essentially without regard to the LO compensation rule. There could be some instances where it comes into play a little bit somehow, but as a general matter, they're not covered by the LO comp rule. On the other hand, if you're originating, and the rule doesn't make any distinction between you're a branch manager, you're a loan officer, you're anything else, it's loan originators, the term that's used in the rule. And so if you're a loan originator, then the CFPB, this has come up many times, and they would tell you that you can't make the loan originator, regardless of title, pay for concessions. It would have to be, the company can bear whatever concessions costs it wants, but the loan originators themselves cannot, according to the CFPB.
Yeah, and I think a point of clarity there is you're right. If you're a branch manager and that's all you do and you're not originating, by definition, you're not a mortgage loan originator. So the rule doesn't apply. I mean, like you said, except for maybe certain situations. But if you're originator, then it does. But if you're a branch manager who's originator, the question becomes, can you be a little of both? I'm not originator, but I am. And, will the CFPB make a distinction between the two and take them apart? Or once your originator is a branch manager, it sucks everything in even there, and it convolutes the issue, even as your branch manager hat is being worn. So I think this requires, in my opinion, these are going to, when you have situations of a producing branch manager and how they get paid and how you want to protect yourself, I do believe requires, again, these are one of those, it depends. It takes a deep conversation with your compliance and legal consult to figure out what is the right answer for you and what risk you might have to assume in doing that. So there might be ways to do it, or at least to mitigate the risk, but we don't really know because the CFPB has not spoken on it directly. So something to think about. And again, always talk on this one. I think you really have to talk a little more granular on the fact specific. What are you doing? How are we doing it? How do we articulate it? And here's the risk. And then someone can make that decision. I think that's where we are with this one.
Yeah, I think that's right.
All right, next question. When companies allow for variations of borrower-paid compensation, it becomes a fair lending issue that should find its way to the, quote, other laws, close quote, that are affected by these concepts. Correct. I think what they're saying here is, again, in borrower-paid compensation, I'm going to use it in a wholesale environment, right? Where you have a broker situation and the borrower is paying the compensation, the lender, do they have control of what the broker can do and charge directly to the borrower when it's not lender paid? And I think the answer is, well, they do have a dog in the fight. I think it's the question is, do we have a dog in the fight? Can we say that, well, but how you pay and how you charge might have some fair lending implications? And let me speak on fair lending real quick. And the answer is it could. I think the bigger issue is we have deviation. Fair lending becomes a fair lending issue when there's a pattern of practice in which it will show that there is this disproportionate effect on particular protected classes. So in that sense, but we don't know that's the case at the moment or even ever. So but my point is, even if we don't have a fair lending issue, I still have concerns that it might be a UDAP issue or something else, that they're charging borrowers more than their comp agreement with the lender. I'm talking they meaning the broker.
Right.
Thoughts on that, Troy?
No, I think you hit it right on the head. It's a question. This only comes up, first of all, like you said, it's only in the broker context. So borrower paid compensation only occurs when there's a broker involved, and the borrower is paying the broker directly. And so if the broker is charging borrower one X amount and borrower two Y amount, could you have a fair lending issue? Yes, as a broker, you could. You might not, but you could. And similarly, as the wholesale lender, could you have somebody, a CFPB, some other regulator come in and say, well, look, these are really your loans, and these borrowers are paying differently, and they correlate to some class, whatever it is. Could you have an issue? In the past, we have seen wholesale lenders settle for pretty big amounts for taking responsibility for the brokers activities are out there engaged in those allegedly impermissible activities. So is it a clean shot for either side? I don't think so, but it does present some risk.
I agree. I think it's clean. Again, some conversation. I think there are defenses, of course, like in this case, there's good defenses as to why you would be allowed to do that in some ways, depending on the detail. But in the scope of the question, is that could be an issue? The answer is yes, it could be an issue. Great question. Next question. Is it okay to pay a loan officer differently for a transaction that is brokered to another lender for loan funding than for a transaction that is retained in-house for loan funding? Now, we know this one's going to come from supervisory highlights, came out recently by the CFPB that found that in a particular lender case, a lender was paying their loan officers differently for the brokered loans. By the way, 100% of the brokered loans were reverse mortgages, and versus the loans that were in-house. And I'm going to say presumptively, 100% of those loans were not reverse mortgages. In other words, they were two different types of loans. And they took issue with the fact that you can't do that. And I think that becomes, what is that? But you can't do that. They didn't like it. And they didn't specify a lot. There wasn't a big write-up, a consent order or stipulation where we can really glean what the thought process was and where they drew the line. So it's a good question. I think the answer depends. Troy, your thoughts?
Yeah, so there is, it's a couple sentences, and it basically says, in our examinations by the CFPB, we encountered this practice and the company changed the practice as a result of our conversations. Boiled down, that's kind of what they said. And it seems to be that the CFPB is taking issue with the brokered loan transactions being paid at one rate and the in-house transactions being paid at a different rate. And so that seems to be part of the equation. So the language, first of all, it's just summary highlights of some examination information that the CFPB put out. It's not a rulemaking, it's not the rule. And I do think that the industry has in large part, from the very beginning, from the time when the Federal Reserve Board implemented a rule back in 2011 on into today, most people, until this summary came out, have viewed this as this is an acceptable practice, so long as you're not basing it on terms, so long as you're not basing it on product, et cetera. You're really saying that it's a broker transaction versus a non-broker transaction. And then we build in the controls that say that only the company, the creditor, can decide when that when a particular loan will be brokered out versus not. So there's some ways to address this issue. There's some different. I think a lot of people are worried about it, concerned about it, and there have been some ideas of how people might address that have been percolating around in the blogosphere and the like, and so it's something really to take quite seriously and look at your plans and analyze your plans and figure out what your risk tolerance is.
Yeah, and I think the first rule is don't pay differently for different products, but no matter how they go. But I think when we flip it on its head and see what you think about this, Troy, in the context of if I were possibly, based on the information we know, and we don't know everything because there was, like you said, it was 2 sentences. Yeah. But if I pay differently for brokering a loan here or keeping it in house, and it's the exact same identical loan, I mean, practically you would never do this, right? I can think of maybe only a couple reasons, and it's a stretch, but you wouldn't do it. But conceivably, if you broker for this and you keep in house here, they're the same kind of loan, but I pay my loan officer less for the brokering, would that be a violation? And the answer is we don't know, because they really didn't. All they said is that you can't do that. We weren't sure that. I think this was more an attack. Attack's the wrong word. I think the focus here was more about they were 2 different products being paid, and not that they were being brokered one and in-house the other. That being said, I don't know for sure what the CFPB thinks about it. I'm saying based on what we know, that could be a possible outcome.
And in the sort of theoretical version of it, I'm guessing that still there would be some difference, like rate or something along those lines, that exactly. Even if it's the exact same product, there's still something that the CFPB, using this logic, could hang its hat on to say, well, you're paying differently, not because it's brokered versus in-house, but rather because some other reason.
No, I completely agree, and that's why I said I don't know why we would ever really do it, but they have to be the identical product with the identical pricing, and then the heck is, well, why would you do it? So, sure. Now let me ask you a question on this. A little bit tricky, because we were talking about reverse mortgages in this transaction, and we know that reverse mortgages, particularly under FHA, most of them are, all of them I think, are ARMs, and a lot of reverse mortgages are ARMs. Some are fixed. We don't know in this fact pattern whether the reverse mortgages were fixed or were they were they were open-ended or closed-ended, correct? I think they would,
right. Yeah, they didn't say, and there's I mean, in fact, most of the getting pinged here for a call I got to run to, but most of the reverse mortgages these days are open-end reverse mortgages, and so those loans in and of themselves anyway are not covered by LO comp rules. The LO comp rule applies to closed-end mortgage loans where the closed-end credit secured by a dwelling essentially is boiled down what the language says. So closed-end credit secured by a dwelling, and open-end by definition not covered, right? But imagine this scenario, and I think this is an area where there could be some risk, although I don't think this is where the CFPB was coming out this time, but this could be a risky area. So let's say I have a HELOC, so an open-end loan, and I also have a cash-out refi, which is a closed-end loan, and I can do either one of those types of products as the loan originator. Well, if I do the HELOC, it's not going to be covered because it's open-end, and if I do the cash-out, it's going to be covered because it's a closed-end loan. Now, if I can do both of those types of loans and I pick one or the other, is that a problem? I don't think anybody really knows. And I don't think certainly the CFPB hasn't really made it clear. Most of the time, I think the HELOCs will be paying less, so there's not really an incentive for an LO to steer towards the open end. But on a reverse, maybe.
Yeah, I agree. I think we don't know enough. We can't say with confidence that if one of the products is open end, that the loan comp rule is completely off the table. I don't know that it is. We don't know enough, and I think that's an issue. So good. Thanks for the extension of that question. I appreciate it. All right, one last question, if I could. I see here. It's a question on steering. So basically, if we do everything correctly, and if we are going to pay differently based on the terms of the transaction, but we can show that we did everything to not steer the borrower into the higher price product, whatever it might be, would we then be compliant with the loan comp rule? I think the question is, so again, I think what they're trying to say is, if I can show that we don't steer, we did everything we could, we got a checkbox, we got recordings, you can do whatever you want to prove that there was no steering involved in this transaction, but we did pay differently based on loan product, would that be okay? Would that make you compliant with the loan comp rule? What are your thoughts?
No, the rule talks to the prohibition is you cannot pay a loan originator based on terms of a loan or proxies for terms of loans, and it's one loan or one or more loans by one or more loan originators. And so, the steering concept, that's part of the underlying rationale for the rule, but the rule doesn't require steering.
Yeah, I think same thing. It doesn't really matter. It's just the idea. I call it strict liability, right? So it's basically, if you've got different compensation for a loan officer, it seems to pattern based on the terms of the transaction, and they're in a position to pivot the borrower one way or the other. You basically have a violation. That's how they're looking at it. Notice that steering isn't one of the elements. Actual steering is not relevant. It's just those strings, and boom, you have liability. So it's almost like strict liability.
Right.
Very good. I think we went through the questions, Troy. Thanks for your time. I think this is a good way to run it out. Yeah. It's kind of fun too. So, well, thank you again.
Yeah, this is great.
Yeah, it's cutting neat, isn't it? So, well, very good. Thank you, everybody, for listening to this. And again, if you haven't listened to the webinar, it's also available. So listen to that, and then it all makes sense, right? Because Troy and I maybe don't make sense now, but once you see that, it makes all sense. So very good. Thanks for your time, and hope you get to watch another Garris Horn Insights in the future. Thanks, guys.
Thanks a lot. Take care, everyone.